Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 22 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between November 11th, 2020 and November 17th, 2020. It was another quiet week for the courts as we roll into the holiday season. The most notable case of the week comes from the Pennsylvania Supreme Court addressing the election code and what level of observation is required during the pre-canvassing and canvassing process. The case is titled In Re Canvassing Observation, Appeal of the City of Philadelphia Board of Elections. This case originated in the trial court with a lawsuit filed by the Trump campaign on the morning of Election Day. The Philadelphia Convention Center was the designated location for pre-canvassing and canvassing of mail-in and absentee ballots. Pursuant to the election code, designated observers for campaigns or candidates were permitted to physically enter the convention center to observe the entirety of the process. A waist-high security fence was erected to separate the observers from the workspace. The workspace was approximately 15 to 18 feet from the erected fence. The observer for the Trump campaign related that he was able to see the employees and observe what they were doing, but was not close enough to see the declarations on the envelopes of whether there were any improper markings on the secrecy envelopes. The Trump campaign filed suit claiming that the 15 to 18-foot distance violated the election code because it did not provide the campaign a meaningful opportunity to observe the process. The trial court rejected the argument, stating that the election code contained no language mandating meaningful observation. Rather, the court interpreted the code as requiring only that the observer be allowed to be present. The campaign immediately appealed to the Commonwealth Court. In reversing the trial court ruling, the Commonwealth Court ruled that all observers be permitted to observe from a distance no greater than 6 feet. The court agreed with the Trump campaign that the election code mandated meaningful observation rather than simply mere presence. In its opinion, the court stated that in order for representatives to fulfill their reporting duty to their candidate, they are required to have the opportunity to observe the process upon which they are to report, and so mere physical presence of the observers was insufficient to guarantee this meaningful observation. The Philadelphia Board of Elections immediately appealed to the Supreme Court. The issue here presents one of statutory interpretation. The objective of the court is to ascertain and effectuate the intent of the General Assembly. It is well established that the best indication of legislative intent is the plain language of the statute. The court cannot disregard the letter of the statute under the pretext of pursuing its spirit. When interpreting a statute, the court must listen attentively to what the statute says, but also to what it does not say. The language of the statute at issue here requires only that an authorized representative be permitted to remain in the room in which the absentee ballots and mail-in ballots are pre-canvassed. Likewise, the code mandates merely that an authorized representative be permitted to remain in the room in which absentee ballots and mail-in ballots are canvassed. While this language contemplates an opportunity to broadly observe the mechanics of the canvassing process, the court notes that the provisions do not set a minimum distance between authorized representatives and canvassing activities occurring while they remain in the room. The General Assembly, had it so desired, could have easily established such parameters. However, it did not. It would be improper for the court to judicially rewrite the statute by imposing distance requirements where the legislature has, in the exercise of its policy judgment, seen fit not to do so. The court finds the absence of proximity parameters to reflect the legislature's deliberate choice to leave such matters to the informed discretion of County Board of Elections, who are empowered by the election code to make and issue such rules, regulations, and instructions, not inconsistent with the laws, as they deem necessary for the guidance of election officers. The court found that the board fashioned the rules based on careful consideration of how it could best protect the security and privacy of voter ballots, as well as safeguard its employees and others who would be present during a pandemic for the pre-canvassing and canvassing process, while at the same time ensuring that the ballots would be counted in the most expeditious manner possible. The Supreme Court can find no basis for the Commonwealth to have invalidated those rules and impose arbitrary distance requirements. According to the Trump campaign observer's testimony, he could view the entirety of the pre-canvassing and canvassing process. allowing him the opportunity to observe the mechanics of the process. Although he could not view the actual declarations on the ballot envelopes, nor examine individual secrecy envelopes for improper markings, this information would only be necessary if he were making challenges to individual ballots during the pre-canvassing and canvassing process, which challenges are not permitted under the Election Code. In so holding, the Supreme Court overrules the ruling of the Commonwealth Court and reinstates the trial court order, finding that the rules and parameters established by the County Board of Elections were appropriate and permissible under the Election Code. There were only 2 other opinions handed down this week. Hughes versus UGI Storage Co, an eminent domain case which addresses whether UGI has the power to exercise eminent domain and whether it did in fact effectuate a de facto taking of the appellant's property, and Hanrahan versus Ketch, which discusses whether a party to a property settlement agreement established in a divorce proceeding must intervene in a bankruptcy action in order to protect their property settlement from discharge. For the full opinion of each case, the link can be found in the case notes. Thank you once again for joining us. I hope you all have a very happy Thanksgiving, and we'll be back with you next week with another Pennsylvania case law update.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.